Okay, so we talked about how the prosecutor selects cases, the ethical, blah, blah, blah. I did tell you that the judicial system is set up to be adversarial. We have two sides. Both sides want to win a case. I explained the prosecution side, they're all gung-ho, they only select cases they think they can win. The defense side of the equation, they don't have that luxury. They have to defend every client that wishes to have an attorney represent them, whether they're court appointed or they hire him personally. So we're going to focus today on the defense side. Legal counsel for the defendant, criminal cases, represents the accused person from arrest to final appeal. That's important when they're talking from arrest, because there's some litigation, and it's made its way all the way up to the Supreme Court, saying that a defendant should be represented during the identification process. The identification, this is key. A person starts off, let's go back to basics. An investigation is started. We believe this person's doing something they shouldn't. So we investigate. Once we have enough information, either we arrest them because we saw an illegal act, or we petition the court for an arrest warrant. Once we have that in hand, we make the arrest. Then they're drugged down to the county jail, where they're charged. Then they can post bail, or they're going to be detained, one or the other. When the arraignment comes around within 24 to 48 hours, that defendant must be properly identified, that they are actually the person being accused of the crime. That can be done by someone who witnessed the crime, or the arresting officer who petitioned the court for the arrest warrant. So let's say it's an officer that witnessed a crime. They came down, they do the interview process. Okay, I'm here, what happened? They're talking to the witness. Let's say in this case, it's a battered spouse. Okay, you beat the hell out of your husband, and he's laying on the ground, unconscious. Okay, neighbors call, officers show up. We're going to place this person in restraints for our own safety. We don't know what she's capable of, so we put her in restraint. Maybe we ask the kids, we ask the neighbors, we ask someone else that was in the house, what happened? Why is this man unconscious here? They explain to us, we have probable cause, we make the arrest. Now we're in court. Fast forward to the arraignment. The case is called. The prosecution must prove beyond a reasonable doubt that the person in custody and being charged is in fact the person they believe responsible for this act. Okay, you guys follow? The defense is going to say, you got the wrong person. This isn't the person that caused this harm. In fact, she has a twin sister. Twins are awesome when it comes to these things. She has a twin sister who did all of this damage, left before the arresting officer showed up. You follow me? Now what's court supposed to do? Has proper identification been made? We don't know. So the court, Supreme Court is saying that during the, remember this is arraignment, they haven't appointed an attorney yet. During the identification part, there should be an attorney representing the accused. Due process says they're not afforded an attorney because they haven't been formally charged with anything. So it gets a little confusing. Okay, so when you're watching TV, what's that, Criminal Law they always talk about? Law and Order. Yeah, that's it, the Law and Order. Or you're watching a movie. How many times haven't you seen somebody take the stand? They're being questioned. And the prosecutor will ask, do you see that person in the courtroom today? And the person on stand says, yes, I do, Your Honor. Can you please identify that person? He's sitting right there with curly hair, yellow shirt. But they do this, right? They point because they're trying to identify the person. Then the prosecutor will say something, for the record, please let it be known that the witness has identified John Doe as a perpetrator, and that's it. The defense will get their opportunity to argue and say, no, it wasn't this person, it was another person. It was the other guy. That's actually a good defense. It wasn't me, it was the other guy, or somebody else. That's the defense's job. They're entitled to legal counsel. It's just a matter of when that entitlement kicks in. It's being argued, so you're up to date. Should it be from the point of arrest, or do we still do it at arraignment the way it's currently set? Experiences, many role conflicts. The defense attorney. I've seen attorneys who don't give a damn. Drake always talks about that as attorney, didn't care, spent very little time with them. Yeah, I've seen that. And I've also seen attorneys that will sit with their client, discuss the case, and shed tears over what's going on. They're that invested in this case. That's also not good. We should never get emotionally invested, but sometimes it's hard. The defense attorney should care about the outcome, that it's fair and equitable. Not just to make sure that my client walks scot-free, but if they're guilty, to make sure they get a fair trial and a fair sentence. Okay, these are some of the tasks a defense attorney will be doing. They get the case, I think, right? No. After the prosecutor, because the prosecutor has all the information. They present it in court. Once an attorney is appointed to the defense, the prosecutor must, under law, disclose all the information being used against the defendant. And that's done at the arraignment. Everything has to be disclosed. There's a rule, the Brady rule, where that didn't happen, and because of it, the judge ordered a mistrial, and the defendant got the law. It was a critical piece of evidence that the defense chose to withhold. The prosecutor chose to withhold and not share with the defense. Okay? That cost them the case. So they must give you who's seen the movie My Cousin Vinny? Right? One per, come on, guys. My Cousin Vinny, write that down. There's gonna be a test on it. Maybe not a test. Joe Pesci's in it.
It was just on last night.
Was it?
Yeah.
It's excellent. It's a funny movie. You'll love it. Write it down, watch it. Because they do talk about the disclosure of evidence from the prosecutor to the defense. And then there's a word called reciprocity. So the defense must also share their information with the prosecutor. Okay. So, preparing the case for trial. Yeah.
Why must they share their what they're gonna say to each other when it's like a battle to like either put this person in jail or
Yeah.
keep them out of jail?
Because of the due process, it has to be fair. You can't even have a surprise witness. Television loves doing that. Well, I just found this witness yesterday, Your Honor. Okay, I'll allow it. Bull! That doesn't happen. They will continue the case, allow the other half to interview that witness. And then, if the judge feels it appropriate, they'll allow that witness to take the stand. Good question. Everything you see that happens in the courtroom has been rehearsed. Right? There's nothing new. Counsel met in the judge's chamber. They've already said what they're going to do. Both sides have agreed. This is what we're going to do. And the judge says, sounds good to me. Now let's go put it on the record. Then they come out into the courtroom and everybody says, oh good, the judge is here. They already know. They know which witnesses are going to be called. They know what they're going to say. They know what the defense is going to counter with. They know which evidence is going to be introduced. They know everything. Otherwise the system doesn't work. They're not doing anything underhanded. It's just to make it flow better in the courtroom. So when you see that baloney in the movies and on TV, we have a last minute witness. It does happen, but it's very rare. So reciprocity, both sides have to share information. Finally, arguing legal motions. That takes time. I want to file a motion for an expert witness. I need my client to be mentally evaluated by an expert. It's going to take us 30 days. So they have to write it up. You just don't ask for it. It has to be written up in a motion. It has to be presented to the opposite side. They have to agree to the continuance, or it doesn't happen. Unless the judge overrules, then it will. Okay, so legal motions, briefs are prepared, arguing specific points of law. Representing the defendant at trial, sometimes there's a conflict between the attorney and the client. If that happens, the defendant, the accused, can ask the court verbally, I need another attorney. Then you gotta say why. Well, Your Honor, my attorney was married to my sister. They had a falling out, it was an ugly divorce, and I don't believe this person could represent me fairly. What do you think? Judge gonna give him another attorney? Would you? Think about that. Would you? You're the judge. I got a couple of yeses. Who would not give him another attorney? Good. Because it sounds right. And that's what the judge is gonna listen to. Does that sound fair? Yeah, okay, we'll give you another attorney. Okay, so everything must be set before the trial starts. Providing assistance at sentencing. During the sentencing process, the agreed upon sentence, the judge, and both sides agreed to in chambers, now the defense attorney has to go meet with his client and sell it to them. Convince them that this is a good deal, this is a good sentence. Whether we went to trial or it's through plea bargaining, doesn't matter. But the defense has to tell the defendant, this is what we're looking at, what do you think? If the defendant says, yeah, I'm good with that, then they put it on the record. Okay, but both sides have to agree. The judge is going to question that defendant. Do you understand what's happening here? Yes. Then explain it to them. Knowingly, intelligently, and voluntarily. That defendant must acknowledge the sentence or the plea deal, whatever happens. Determining the appropriate basis for an appeal just depends on the specifics of what the appeal is based on. Let's say it is ineffective assistance of counsel. I asked for another attorney. The judge said no. The case starts to roll. Witnesses are called. You're trying to tell your attorney, ask him this, you're sliding notes back and forth. Ask him this, ask him that. And he's just looking at it, or she, and they're just putting it to the side. Not even acknowledging your presence. You're telling them, object, object. They're not doing it. And I told you, remember, if you make an objection on the record, then you can file an appeal on that issue. But you must have it on record or you waive that appeal. So your attorney isn't doing their job. And I've worked with some attorneys that chair could do a better job. Down the road, they ended up getting disbarred. They were on drugs, high as a kite during the trial. Not good, right? How about that's your attorney? So of course, the trial concluded. The defendant was found guilty. They filed an appeal, and then I worked on the appeal as well with another attorney. And ultimately, the first attorney was disbarred. High as a kite. We brought that attorney in, put him on the stand. And now the new attorney I'm working with is questioning him. Have you taken drugs? They go through the whole thing. They set the foundation. Have you taken drugs in the past yet? On this day, had you taken drugs? Yes. Couldn't have been more honest. Threw himself on the sword and then apologized. He's a drug addict. Says I should have never been practicing law. I've since been in recovery, and now he works as a counselor for other people that are struggling with drug abuse. Not a sad ending, but boy, that was a sad case, a very sad trial. Okay, questions about that? Ineffective assistance of counsel, filing appeals, representing the defendant during trial. The right to counsel begins at the earliest stages of the justice system. A defendant who lacks the funds to hire a private attorney is entitled to counsel. It's called indigent, meaning you're broke. You can't afford an attorney. It is done during the arraignment. The judge will ask the defendant, do you want an attorney? Yeah. Would you like the court to appoint you an attorney? Yes. Are you indigent? They usually say, you're broke, you can't afford an attorney. Yes. There's a form they have to fill out. It's not just that automatic. The county has to protect themselves also, indicating that they're in fact indigent, they do not have the means, they sign it under oath, and then the defense attorney is assigned. I mentioned before, there's two types of defense attorneys. One is the public defender's office. Bigger counties, like this one, are we Riverside? Right, Riverside? Riverside County, it's a big county. They have a public defender's office. LA County, San Bernardino County, they're big counties. They can afford to have public defenders. The county I came from, Kings County, couldn't. Right? The entire population of the county was just slightly more, a couple thousand more than Temecula and Murrieta put together. That's it, a couple 100,000. We could afford to have a public attorneys or public office like that. So they had contract attorneys. And I worked for a couple of those guys under contract. In the mornings, they would be in the courtroom. We had, I think, 6 different courtrooms. So they would be in the courtroom. When the judge needed to appoint counsel, they would ask the attorney, do you accept this case? Yes, Your Honor. I have no conflict. They go through the information. They set dates. That's about it. So, 2 ways, public defender or a private contract is how defense attorneys are appointed. A private attorney appointed by the court to represent a criminal defendant who cannot afford to pay for a lawyer. That's the assigned counsel, the contract attorney. And there it is. In the contract system, there is a provision of legal services to indigent defendants by private attorneys under contract. Mixed system uses both. And I explained both, public and private. Okay, now these contract attorneys, they get paid what you would think is pretty good, about $10,000, $12,000 a month. They work maybe 2 hours, Monday through Friday in the morning, to get the new cases coming in. Then they gotta prepare these cases, then they gotta meet with the client, and if it goes to trial, then they gotta represent that defendant in the trial. But put yourself in their shoes. You're getting paid, you don't get paid any more if you go to trial. Okay, you're under contract. So let's say they're paying you $10,000. You show up Monday through Friday, usually about from 9 to 11, to take on new cases. You get a case, and this defendant insists they're innocent, gives you a list of witnesses to talk to, and they're adamant they want to go to trial. Keep in mind, you're only getting paid a baseline salary. Whether you take this case to trial, or you meet with the prosecutor, negotiate a plea, sell the plea to the client. Which would you rather do? Be honest. Are you going to spend hours and hours and hours of your time to defend this individual? Or maybe 1 hour meeting with the public defender, negotiate a plea, sell the plea to the defendant? Which would you do? Easy way out. Isaac, what would you do?
I think we'll negotiate the plea.
Negotiate, huh? Who wouldn't want to just negotiate the plea? Okay, what would you do? You're the next. Go ahead.
Depending on like what evidence they provide me,
Huh?
and like seeing how passionate they are that they are innocent, I would probably go and actually spend my time to work it out, because otherwise I'd have it on my subconscious that I could have done more.
Okay, when you're an attorney, you have no subconscious. You have no conscience. You don't care. It might take a couple years to get there, but you will get there. Even the most caring of attorneys, very few still care 10, 15 years later. That gets old. Caring gets older. Because you get burned. That person that you thought, oh yeah, I'm gonna represent them, they're lying to you. They usually aren't. They really are. What my guys would do, my contract attorneys would do, they called me. And they'd say, we need you to go interview the defendant. Find out if these witnesses are legit. Interview them. Prepare a report, bring it back to me. Okay. I tell them what I charge. They petition the court for the funds. I get the It's a declaration saying I could spend X amount of money. And we're not thousands of dollars. Now, I do the legwork. I submit the report, give it to the attorney. And usually they always want to know what I think. And on the bottom, to settle the case. He's lying. Witnesses are untrustworthy. They've been coerced. They're not credible. There's a lot in these reports. Now the reason I could do this, and I don't have to worry about disclosing it to the other side. Remember I said you gotta disclose everything? Because this is called attorney-client privilege. Privileged information. My reports don't get shared with anyone unless the defense attorney wants it to be shared. And most of the time, we would share it with the prosecutor if we had good stuff. And I did have some good stuff every once in a while that would tell him, prosecutor, you don't want this case, you're wrong. 90% of the time, they would dismiss the case. 10%, they'd still go for it. They're about 50-50, sometimes they won, sometimes they lost. But it's very credible when a good investigator does their job. Remember, my job was, I was the hired gun. Whoever paid me the most money, that's who I represented. Doesn't change the facts. The facts don't change. Just how much money I can get. And who's willing to pay. Whether it's federal, state, I don't care. I'll go and do the work. All right, so, contract system. I work for the private attorneys. Rarely will the public defender hire me because they have their own investigators in the district attorney's office. So they'll send them. Right. Sometimes I'll even work with the prosecutor's investigators. We'll sit in the same room interviewing the same witnesses, especially if it's capital cases, stuff like that. Okay. Research indicates that state-appointed attorneys do well in court. Private counsel may have a slightly better track record, but court-appointed attorneys do quite well too. The private attorneys, I told you they go to the court maybe a couple hours. These are regular attorneys. So if you're the defendant and you want to hire, I'll tell you his name, Jim Oliver, one of the better criminal case attorneys in Northern California. If you want to hire him, you're going to have to pay maybe $2,000, $3,000 retaining fee. Then it's another $250 per hour. While he sits there and talks to you, stands in court, whatever he has to do. If we go to trial, he's going to double that. It's going to be about $500 an hour. Then he hires me. Now you're going to have to pay me about $150 an hour to go do all this work. That tab gets elevated quick. So on a simple felony case, you're going to look at about $20,000 to $25,000 to hire Mr. Oliver and myself. Or you're indigent. And the court appoints Mr. Oliver, who hires me, and the county pays me. You're getting the same counsel and no money out of your pocket. That's why the private attorneys do so well working through the court. They don't like it because they can make a lot more money if you hire them privately, but they like it because they build up the clientele. You have a question or?
I was kind of say the guilt part of it.
The guilt?
when you were talking
Okay.
about-
Yeah, that goes away fast. Okay, if you are arrested, now put yourself in this place. Think of a serious felony. Would you prefer to have a paid private attorney, or would you go with a public defender? Think about it, and then answer why would you make that decision? Do you think the likelihood of being found guilty depends on the counsel, whether it was private or contract? Think of a case. When I go into domestic violence, that happens whether you're married or boyfriend, girlfriend, or boyfriend, cow, mule, sheep, whatever the heck. I watched a special last night. With George. Okay, let me be fair. I watched 10 minutes. And what the hell? But I get the idea. You're involved in a relationship. It goes back. And if you're a female in the class, then put yourself in the female role, but you're the aggressor. You did something wrong. The significant other cheating on you. So you found a knife. And it was a weapon of convenience. So it's not premeditated. Maybe you're chopping lettuce. And you see a text coming. Son of a bitch. Right? Where is he? Stab him another time. Hey. Hey, that's you.
It's gotta be subtext.
Stab him. Didn't kill him. Son of a bitch. No. But you did some damage. You stabbed him. Now you're in front of the judge. That's you standing there. They're reading all the allegations. Are you going to hire a private attorney or will you go with a court appointment? Why? And you think your odds would have been better. Odds of winning would have been better with either of you. Think about that. I want to see some deep thoughts. What do you think? What do you think? What you were staring hard.
I was thinking over the time,
Private?
yeah, because people know they don't get paid a lot, and still think that they can represent it, you don't gotta pay all that money.
Oh, so you're thinking public defender?
Yeah, yeah,
Court
public
appointed.
defender.
Okay, court appointed or public defender, because you don't have to pay that money.
Yeah,
And then you will pay them,
yeah,
so you're willing to hold the position.
yeah.
Okay. Good, good. Anybody else? I thought you were gonna say something, you just didn't.
Oh, no.
Who would you go?
I would go with, if I had the money, of course, private and a female.
And a female.
And a female.
Why a female?
Because then obviously she would probably be more able to like sympathize and then also be able to present to the court as a woman, you know, if a man is beating up on you or if he's cheating on you.
So that's her
then
defense.
what would be?
You have been beaten on me and he cheated on
Yeah.
you. That's why I stabbed her.
Right.
Okay.
That's right. I mean, if I had the money, then that's correct.
Okay. But what if you didn't have the money? Would you put your house up, borrow against it, beg, borrow, steal money from family and friends to hire a private counsel? Okay. Would you do that?
I don't know. I wouldn't want to put my house up. I'd probably just stick to a public defender.
Go with public defender?
Yeah.
Okay. Let's get some guys.
I would get my political science teacher, since he's a lawyer.
You'd be surprised how many students have called me when they get in trouble, asking for advice, and then if they can hire me. I'm not doing that, it's a conflict. I kind of give a little bit of advice, but that's it. So you would try to get somebody you know, a teacher. Okay. Maybe they would take the case. Is he adjunct?
I have no idea, he doesn't really talk about his private life. He says that he's a lawyer and for like his full-time job and then he's part-time.
Then he's adjunct, yeah, he's part-time. We got a lot of good part-time instructors because they're still working in their career. I got quite a few in our department. There's still cops on the street. No, I was already retired when I started, and Farrar, he retired first, then started. So sometimes you get some that are still active, and others that are looking to do something in retirement. Let's get some guys. What would you do? Not that you're raising your hand, but
If, let's say, it happened right now, like in my current situation, my current financial
Yeah.
situation,
okay.
I'd probably just choose a public defender. Public defender,
Mhm.
just because I can't really afford.
Because of
anyone.
affordability.
Yeah.
Okay. Let's throw this out there. How many of you, if you had unlimited resources, so you could afford to hire a private attorney, how many of you would actually hire private? Really? Okay, honestly, yeah.
Because your chances will slightly better.
Yeah, you think you're slicing. Remember early on, maybe a week or two ago, I asked about, is justice fair? And then most of you would, oh hell no. And I said, no, justice depends if you got money or not. Right? The more money you have, the more you can get out of the judicial system. Unanimously, whether you guys realize it or not, you just agreed with that comment. By raising your hand saying, if I had the money, I would go private. But now think of all those people sitting in jail right now that are there because they don't have that money. Now, is our judicial system still fair? Makes it hard, huh? Makes it hard to think, yo, no, we're great, we're fair, due process, we have rights. We do, but it's not always fair. Okay? Questions on that idea, that bomb I dropped on you? No? Anybody disagree? Makes sense, right? You guys already agreed that if you have the money, you can get the best money can buy. But because you don't, you're stuck with a public defender or a contract attorney. Okay, conflicts have helped erode the formal justice process, which is based on the adversary system. The informal justice system revolves around the common interest of its members to move the cases, move them along, settle them, next case. We do that, see if everybody reads it. We do that through plea bargaining. Whether you like plea bargaining or you think it's the worst thing in the world. I believe the latter. I don't like it, but there's a big but. But I do realize that's a necessary thing. Okay, plea bargaining. They have, it's called a West plea. It's known by two different names. I know it by West plea. West is a case. The district attorney's office made the offer to the accused that if you take this plea, this deal, this is what we could do for you. We'll drop some charges, we'll ask the court for the minimum on the others, we'll waive fines. And the defendant's sitting there telling the counsel, but I'm innocent. I didn't do these things. But because of the offer being made and the likelihood that this person was going to be found guilty, they took the plea. They noted for the record during the sentencing that they're only accepting the plea because the deal was so good they couldn't pass it up. When a judge accepts that plea, whether it's just a guilty plea, no contest, or I'm guilty but, you have to admit guilt. You have to take ownership. And you have to show remorse. Or the judge will not accept that plea. So when this defendant got up there and said those things, well, Your Honor, I will take the plea, however, I'm not really guilty. So noted for the record, they went ahead and sentenced this guy. Now the Supreme Court, the highest court in the land, gets this case. They acknowledge that plea bargaining is a necessary evil. They have to have it to clear dockets, to keep these cases moving through the judicial process. So they call it a West plea. Now, if you want to take advantage of the plea, the bargain that's being offered to you, but you don't want to admit the guilt, you can plead guilty and say, I'm only taking this deal under West plea. Now the court doesn't ask you to accept guilt. It doesn't ask you to knowingly, voluntarily waive any rights. You're only taking the deal because it's so good to pass. When I saw that happen, I said, you've got to be kidding me. That's how hard up these courts are right now to clear these cases, to keep them moving. That the Supreme Court came up with a loophole to allow this to happen. You don't have to admit the guilt. You don't have to accept responsibility. Now remember, if this is destruction of property where there's some type of restitution involved, if you plead guilty during the criminal course, the criminal trial, then they can use whoever the injured party, the aggrieved party is, they can use the outcome in a civil case and now take you to court and say, you got to pay back all this money. No contest plea, that waives all that civil action, as does the West plea. It waives any civil type of restitution. So you can openly admit guilt and not have to worry about that being used against you in a civil case. Think of OJ. Found not guilty in the criminal case, but in the civil, he got slammed, lost everything he ever had. Two things happened there, obviously. The level of guilt being used in a civil case is called preponderance. We talked about preponderance versus guilty beyond reasonable doubt. Guilty beyond a reasonable doubt, that's in a criminal case, criminal offense. 12 jurors have to agree this person committed this act. In a civil case, you only need preponderance. And remember, people think, oh, that's 51%. It's not. You only have to believe it a little bit more than you don't. That's preponderance. Scales. Equally balanced. Take a grain of sand and tip the scale. That's preponderance. That's dangerous. Okay? Anybody can convince a court in preponderance. So avoid it at all costs. Okay, questions about anything we discussed so far? No, everybody's happy. Got a couple of these sentencing videos, then I'll get you out of here. We'll keep that going. Get the videos going.
Boo the dog, dancing pandas. How does a tough-talking small-town judge make the cut? Well, the one you're about to meet is not your average gavel-banging magistrate. His Honor's got a unique way of dispensing justice to the people who show up at his courtroom. And as it turns out, it's shockingly successful. Here's ABC's TJ Holmes.
He's the kind of judge no one can forget.
Right, please.
On August 6th, probation violation, you entered a plea of not guilty.
Fire question for you. Does that mean I still can't drink on probation?
You really asked that question when I just said I don't think he has an alcohol problem? Did you take your dumb pills today?
Judge Chickanetti of Painesville, Ohio, or Judge Chick, as he goes by, sees 30 to 40 cases a day, but it's his unique method of sentencing that has turned him into a viral sensation.
And now to this story, an Ohio judge defending an unusual punishment.
Gave one teen a punishment she definitely will never forget.
18-year-old Victoria Basca takes the cab ride that sticks the driver in the end.
The teenager who skipped out on a cab fare to a long walk of shame.
Just a few months ago, one of the judge's latest sentences got international media attention.
When 18-year-old Victoria Bascom was given a choice, spend 30 days in jail or walk 30 miles.
I've never been to jail and I don't want to go to jail. I'm kind of upset about this sentence, you know, because I'm thinking I was going to go on and have to just pay a fine. Like, it's only $100.
When did that idea pop into your head to, you know what I'm gonna do with this girl, I'm gonna make her walk?
It just came to me, and I even asked her, I think this is where it came in, when I said, if you didn't have a cab, then what would you do? She'd go walk. Then I said, let's make her walk 30 miles. So I gave her the choice of 30 days in jail or 30 miles.
I ended up almost getting jail time, so I guess like kind of lucky he gave me this option.
But this kind of creative sentencing is not new to the judge. He's been doing it for years.
Very humiliating, very embarrassing.
After being arrested for soliciting a prostitute, this man chose public humiliation over jail time.
Is this tough enough punishment that you're never, ever going to be doing something like this again?
Absolutely.
This teen stole porn from an adult bookstore.
I'm thankful that Judge Chickanetti gave me an opportunity instead of a jail time.
This woman was caught on surveillance tape, walking into a Burger King and pepper spraying one of the workers in the face. Her sentence? The judge gave the defendant a choice. Either serve time or get sprayed herself with what she thought was pepper spray.
And you couldn't use the real pepper spray, because you can't injure somebody.
And now I am bucking heads with football professors when I use real pepper spray. Now we're getting into the cruel and unusual.
Did the victim get the vengeance in that case, given that it wasn't real pepper spray?
Yeah, may not be what you wanted, but it's all that I could do as the law permits.
But it scared the hell out of the
Scared,
defendant.
yeah, but it scared the hell out of the defendant, so it served its purpose.
This is your one chance, it better be good.
Judge Chick may be onto something.
A judge can simply follow the law, and if somebody committed a crime, here are the possible penalties, how much of that do I impose? Sure, you can do that, and you go home and you can rest easy. Or you can take each case a little more personal, and still apply that same law.
The rates of repeat offenders are much lower in his courtroom than the national average.
When you talk about state prisons and federal prisons, their problem started way back here with my court, with municipal courts, with the minor offenses. most people don't start out with a felony, okay? We have to stop them from going further at the beginning stages. Then otherwise it escalates. They get in jail, they get smarter criminally. And as they get smarter criminally, the offenses become greater.
On the docket for today, 2 cases. One involving a bicycle theft, and the other, a case that hit a little close to home for the judge.
Who's being silly? Who's being silly?
As a pet owner, he was extremely upset about how Alyssa Morrow treated her pit bull Nix.
I'm about to read the report.
This is how animal control found Moose in a house that can only be described as belonging to a hoarder. Morrow says she left him there for just a week. She's in court today, pleading guilty to animal neglect and cruelty.
You know, I can't interpret the feelings of a dog, but boy, if dogs could tell you how they felt. Oh yeah, and scared, and frightened, and sick. Well, maybe you should get a little taste of that. But I'm gonna let you have choice here. And the choice is I want you to live like Moose. And in order to do that, I want you to go down to the county dump, to the landfill. And I want them to find the stinkiest, smelliest, god-awful odor place they can find in that dump. And I want you to sit there for 8 hours tomorrow. Just think what you did to that dog while you smell the odor. If you puke, you puke. Understand?
Morrow has the choice of either choosing to do this alternative sentence or spend 90 days in jail. She agrees to go to the dump.
Okay? See you at the dump tomorrow.
We'll get to the dump later, but first, the case of the disappearing bike. The defendant, Jordan Walsh, showed up to court with his mother.
All right, Jordan, you stole a bike, walked into the garage, took a bike and rode it.
Well, Your Honor, I know Mr. Walsh takes full responsibility for this.
For the punishment, and I think to get your attention that it's not to be done again, as I always do, you're gonna have the choice of 60 days of jail. You can avoid that by 10 days of community work service, because you stole a bike and you rode the bike, so that's what you're gonna do again on Tuesday in a fair parade.
The judge has made him an offer he can't refuse. He ordered Walsh to ride a bike on behalf of a local charity in a parade the following week.
You worried about going to jail?
6 days, when I heard that, my heart just dropped.
And the guy that got his bike stolen is surprisingly supportive.
I didn't want that kid's life to be ruined because he stole a bike, but, you know, he's to pay for what he did. Embarrass him a little bit, it's better than sitting in jail.
He rode the bike all along the parade route.
I think it's better than going to jail because I can show people that I could do better in my community.
For Alyssa Morrow, her second chance came the day after court at the local dump. And she was given the ironic job of picking up garbage.
Girl, not the best outfit choice.
I know the shoes. I thought about it. Since I know the shoes, I was already running late, so.
For the next 8 hours, Morrow must spend her day just like Moose spent close to a week in Philly.
Definitely don't think I'd be here, but I'd rather be here than jail. Can't complain.
The good news is that Moose is recuperating wonderfully and is now up for adoption. For Nightline, I'm TJ Holmes in Painesville, Ohio.
Okay, what do you think? Creative sentencing. Judges have so much knowledge. Very few of them actually do things like this. But how appropriate. The time, the punishment should fit the crime. Right? Fit the crime. That lady with that dog, oh my goodness. 8 hours, that's all she got? I'd have made her live in something else for at least the same amount of times that poor dog.
Well, didn't he just say a week?
8 hours in the dump. The dog was left unattended for almost a week. That environment. That's sad. That's sad. I got one other one. It's the same judge.
Next, we're in Charleston, West Virginia for a pretrial hearing.
Andrew E. Eldon, Andrew E. Eldon, Andrew E. Eldon.
Henry T. Eldon is in the courtroom, but he...
Okay, no, I wanted to show you, I didn't use another one from the same judge. This is a different judge, and he's dealing with, you can see it up there, a stubborn citizen who says they're not a member of the United States. there's something else, yeah, watch this.
Is refusing the magistrate's order to come forward to the defendant's table.
Get up here in this seat right now.
That's right, the judge called him thrice. Eldon is facing multiple charges, including fraudulent official proceedings and fraudulent service of indebtedness related to falsely filing claims with the court. Today he's joined in the courtroom by a friend who's recording the proceedings on his cell phone and getting involved himself.
I'm a witness, okay? Okay, what I'm saying is, he is present, and he's chosen not to step up there. He's asking not for a point of lawyer, he doesn't need an attorney.
So you're acting in the capacity.
I'm not acting, I'm a witness, just an American national.
American National is another nod to the sovereign citizen movement both he and the defendant identify with. Eventually, Eldon does respond to the magistrate, Ward Harshbarger, but still refuses to come forward.
The court order has to be established before anyone can proceed.
Well, okay, well, get up in your seat now and we will wait for that. We have some preliminary thing.
We're all waiting for the court reporter to be.
Do it now. All right, this is State versus Henry C. Eldon Jr. Mr. Eldon, I need you to have a seat at the defendant's table.
For the record, I'm a
Shut up and
witness.
sit down. You sit down and not say another word.
Seemingly getting more aggravated, the magistrate turns to his courtroom deputy for assistance.
Would you do this? So you want to see this, please?
May I have persons?
You may have a seat right there. You may have a seat right there.
Eldon finally gets up to the stand before the judge, but it won't be for long.
You are going to be held in contempt.
All right, Mr. Eldon, will you stand up when the police come out and place your hands behind your back? You would. And who are you? And do you have a warrant, signed warrant? I have a warrant. I've just been made aware by the judge that he wants me to take you into custody for a constructive judicial process, okay?
But before the magistrate had the defendant arrested and cuffed, he pulls a final move out of every parent's playbook and counts to 3.
Have a seat. 2. Have a seat.
I would like to speak, and I have information to present. I don't know how I'm instructed.
Last warning, get in the seat and we'll proceed.
Again, locked in a stalemate, the magistrate decides to just get down to business.
How do you plead?
I would like to see your oath of office. I'd like to see your letter accepting and acknowledging your office. And I would like to see the same for the prosecuting attorney. And to know the names of everyone in this room. I need that before I understand what's going on, sir.
So the answer, and I will answer for them, is not guilty.
I haven't made any plea, nor should you make any
All
plea.
right.
I don't accept that. I don't accept anything
Whether
second
you
to that.
accept.
I did not in your opposition.
Spoken out.
Order adjourned.
The court wouldn't confirm the details, but according to Eldon, he did not appear for his next court hearing and was arrested on a bench warrant and served 2 weeks in jail. He also says the original fraudulent service and fraudulent official proceedings charges against him were later dropped.
Thanks for being a fan of Court King.
Okay, what'd you think of that one? A difficult defendant.
I love court.
You want to check the camera?